Hello and welcome everyone to our webinar on workplace policies, what every employer needs to know. We're really glad you can join us today. My name is Dickson Wu and I'm a senior lawyer in LegalVision's employment team, and my co-host is Amelia Diskoros, who is a lawyer in the team. Now, before we begin, there's just a couple of quick housekeeping items I wanted to highlight. You'll see those on the screen. The first being that you'll receive a copy of the recording of this session, as well as the slides in your email. Secondly, we're going to have a dedicated time of Q&A, so feel free to submit your questions in the chat box. We'll try and answer as many of them at the end of the session, as well as some of the questions that you might have pre-submitted before the webinar. Finally, we really value your feedback. So we always have a feedback survey at the end of the webinar, and we'd really appreciate it if you could fill it out. We're always looking to see how we can improve and make these webinars as helpful as possible for you. Another thing I'd like to flag is that for the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business, whether that's related to employment, workplace policies, or other matters as well. If you are interested, please feel free to provide your contact details in the survey at the end of the webinar. So today we're going to be discussing what you need to know about workplace policies. And specifically, we're going to be running through the Australian employment framework, the different types of policies, including legal and operational policies, what to do about employees who don't comply with workplace policies, as well as some practical tips for developing and implementing workplace policies. And as I mentioned, we'll have a time at the end, leave as much time as possible for Q&A. So let's kick off. To set the scene for our discussion on workplace policies, let's just firstly consider the framework for employment rights and entitlements. So in Australia, employees have rights at work under the National Employment Standards, the NES, industrial awards, and employment agreements. And you'll see a pyramid there on the screen. And what that image does is depicts where an employee's rights and protections come from. So you'll see there the base is the minimum threshold of rights that an employee is entitled to, and each additional layer offers greater rights and protections. It builds on top of each other. So as an employer, you cannot avoid the rights and obligations set out in the bottom two layers, being the NES and any applicable award. So for example, we couldn't lawfully have an employment contract or a workplace policy, which provides that a full-time employee accrues less than 4 weeks of annual leave in a year. So let's just now consider each of these instruments. First one being the Fair Work Act. So the Fair Work Act provides the legal framework for the national workplace relations systems, which is really just the majority of workplaces in Australia. There are some state government employees, as well as some businesses in Western Australia, who are engaged under state-based systems, so not the Fair Work Act. What the Fair Work Act does, it contains the National Employment Standards, or the NES, and this sets out 12 minimum entitlements that apply to employees. And these relate to a range of different entitlements, as you can see there on the screen, such as requests for flexible working arrangements, casual employees being able to request conversion to permanent employment, paid and unpaid leave entitlements, such as annual leave, sick leave, compassionate leave, as well as redundancy pay, and the provision of certain Fair Work information statements. So that's the Fair Work Act. The next instrument we'll look at are industrial instruments, which are mainly modern awards and enterprise agreements. So the Australian workplace relations system, it's underpinned by what we call modern awards. And these documents, these instruments regulate employment in particular industries and or occupations. There are currently over 120 modern awards in effect, and they provide conditions of employment such as pay rates, hours of work, breaks, allowances, penalty rates, and overtime rates. Now, an enterprise agreement operates similarly to a modern award. However, it's negotiated with a business rather than being set for a particular industry or occupation. Next up, we have employment contracts. So employment contracts are legal agreements between employers and employees, and they outline the terms and conditions of the employment relationship. You may have all seen an employment contract before, whereas as an employer, or maybe if you've ever been an employee. And you'll notice they often include common terms such as the hours of work, the remuneration, termination notice periods, as well as some key protections for the employer around your confidential information, intellectual property, and restraints of trade. Finally, the workplace policies, which of course is the key subject of our webinar today. Workplace policies, put simply, they're written directions from employers to employees. And as an employer, you have a right to make lawful and reasonable directions to employees. And Amelia will explain a bit more about what that means. And policies are really one way to just effectively communicate any such directions. And they can set out how you want your business to run and what behaviors you expect from team members. Workplace policies can also address discretionary benefits that are provided by an employer, such as paid parental leave. So I'll now hand over to Amelia to explain the different types of workplace policies.
Thanks, Dickson. Firstly, it's important to note that policies are essentially a collection of lawful and reasonable directions from an employer. As an employer, it's important to ensure that your policies are lawful and reasonable in the circumstances. A direction will generally be unlawful if carrying it out would breach a law or the terms of the employment contract. What is reasonable in the circumstances is essentially a question of fact and balance, and there may be a range of factors that are relevant, including the express and implied terms of the contract, the nature of the employment, established customs and practices in the workplace, trade, or industry, and the terms of relevant instruments such as a modern award, enterprise agreement, and any applicable legislation. There are two main types of policies that an employer can implement. These are legal policies or operational policies. Legal policies typically contain rules and procedures designed to ensure an organisation complies with applicable laws and regulations. Legal policies can also protect employers against potential liability, where an employee has failed to comply with the applicable policies. The core legal policies that we recommend every employer should implement include an anti-discrimination, harassment and bullying policy, or ADHB policy, a work health and safety policy, and an IT policy. Now, let's consider each of these policies. Firstly, an ADHB policy prohibits discrimination, harassment, and bullying in the workplace and outlines what this conduct looks like in practice and how it can be avoided in the workplace. It should also outline complaints procedures for reporting conduct in breach of the terms. This policy is particularly important due to amendments to legislation, which now account for a positive duty for the employer to eliminate discrimination and harassment in the workplace. The second policy is a work health and safety policy. All employers must take reasonable steps to eliminate or reduce hazards to health and safety in the workplace. A work health and safety policy is a reasonable step that all employers can take to help meet this obligation under WHS laws. A WHS policy should broadly outline the obligations of the business, managers, and workers in relation to WHS and establish consultation processes. An IT policy is the final policy that we recommend from a legal perspective. An IT policy governs acceptable use of company technology and data and outlines security measures to protect sensitive information. It may also set guidelines for email, internet use, and software installation. An IT policy can also provide the basis for how the business is allowed to surveil its employees' use of their IT. Whilst these policies are considered essential from a legal standpoint, other policies may also be valuable in setting out processes and expectations of employees. For example, a common topical question that we have received has been whether an employer is required to implement a right to disconnect policy in light of the recent amendments to the Fair Work Act, which has introduced a right for employees to refuse to monitor, read, or respond to contact or attempted contact outside of working hours unless doing so is unreasonable. Whilst it is not a legal requirement to have a right to disconnect policy, an employer may wish to consider implementing a policy exclusively for managers on the right to disconnect, which educates them on out of work hours requests and can help to avoid potential disputes in relation to the right to disconnect. Operational policies, on the other hand, are defined as internal guidelines that dictate how an organisation conducts its day-to-day activities and processes. Operational policies are technically not required. Whilst it may not be a legal requirement, sometimes these policies are requested by clients, such as under government contracts or throughout a tender process. Examples of operational policies include a leave process policy or a grievance policy. Employers should be mindful regarding the operational policies they implement, as employers can be held liable where they have failed to comply with their own operational policies. For example, consider a situation where an allegation of misconduct has been raised against an employee, and the employer has an investigation procedure policy in place for dealing with the misconduct. If the company does not comply with the investigation procedure outlined in that policy, and they continue with dismissal of the employee, compliance with its internal policy may have a bearing on whether the process followed was procedurally fair in the context of an unfair dismissal claim. I'll now hand over to Dickson to touch on non-compliance with workplace policies.
Great, thanks, Amelia. So I guess the big question is, what can you do as an employer if an employee doesn't comply with a workplace policy? So the first thing to note here is that an employee's failure to comply with the lawful and reasonable directions contained in your workplace policies, it constitutes misconduct. And depending on the circumstances, your next step may be to conduct an investigation in relation to the non-compliance and provide the employee with an opportunity to respond to your concerns. Your next course of action may then be to provide some informal counselling to help the employee better understand workplace practices and expectations, or it could be to take disciplinary action, such as providing a verbal or written warning, or it could even lead to dismissal. Now, to warrant dismissal, the particular direction in the policy, it generally needs to be shown to be fundamental to the contract of employment. However, a persistent refusal to follow lawful and reasonable directions may justify termination of employment, even though each direction itself may not be significant. Now, there's also what we call serious misconduct, and an act of serious misconduct will, in principle, provide justification for immediate dismissal. There is a definition of serious misconduct, and for the purposes of the Fair Work Act, that definition includes an employee's refusal to carry out a lawful and reasonable direction that is consistent with the employee's contract of employment. And so, depending on the severity of the breach, a single act of disobedience can be sufficient to justify summary dismissal. But in this regard, the employee's disobedience must be shown to be willful or deliberate. Now, before taking disciplinary action against an employee for disobeying a direction in a workplace policy, there are some matters that we think you should firstly consider. First being, was the direction actually lawful and reasonable? Secondly, was the employee required to read and acknowledge the policy? Thirdly, was the employee made aware of the consequences of failing to comply with the direction? Fourthly, has there been any inconsistency in your implementation of your directions or policies in the past? And finally, would the proposed disciplinary action be proportionate in the circumstances? Now, to illustrate this in a case example, back in 2019, we have a case here where there was an applicant who was employed as a casual general hand, and a new company policy introduced fingerprint scanners to record worksite attendance, and employees were advised to register their fingerprints to record their attendance. Now, this particular employee submitted that biometric data is sensitive personal information under the Privacy Act, and so the employer was not entitled to require that information. So what did the employer do? The employer addressed the employee's concern by giving them a document from the supplier, explaining the nature of the data that was going to be collected. And subsequently, the employer issued the employee with a verbal warning as well as written warnings when he failed to comply with the new company policy. The employee was subsequently dismissed because of his refusal to use the fingerprint scanner. And so this went to this case went to the full bench of the Fair Work Commission, who found that the employee was actually unfairly dismissed and held that the direction to comply with that company policy was unlawful because it was a breach of the Privacy Act, and that the employee was entitled to refuse to follow the direction. So in light of this, it's important to ensure that workplace policies contain lawful and reasonable directions. And I'll hand it over to Amelia to address the implementation of workplace policies.
Thanks, Dickson. The first step is researching and defining policy terms. The policy should be explicit and define key terms used throughout, so the employee can understand what is meant by the terms. For example, in an anti-bullying and harassment policy, bullying should be clearly defined. Market research is also helpful to understand what similar organizations have implemented in relation to certain processes. For example, market research could be very helpful in developing an operational policy, such as a paid parental leave policy, to gauge what your competitors are offering to its employees. Policies should also explain what is acceptable and what is unacceptable behaviour in the workplace. You may wish to include specific examples to illustrate problem areas or unacceptable types of behaviours. You should also be clear about who the policy applies to. For example, does it only apply to employees or to contractors and subcontractors engaged to perform work on business premises? Now let's consider how to draft the policy. Policies should be written in plain English and easily understood by all employees. Employers should also be mindful of using promissory language in policies. Promissory language can create a contractual obligation where it is not intended. For example, in an internal incentive scheme policy, promissory language such as "you will be entitled to" may create a contractual obligation. Consider rephrasing this to "you may be entitled to" avoid this. However, it's important to note that promissory language can be appropriate, particularly where you intend to set clear requirements of employees. For example, in an anti-harassment and bullying policy, it is preferred to use promissory language to make clear that employees must avoid certain conduct. Policies also generally should not be overly prescriptive, otherwise they can reduce management discretion in dealing with workplace issues. Policies should also include a term which states that contravention of the policy may result in disciplinary action up to and including termination of employment. Implementation is also key to a successful workplace policy. A policy should not be a piece of paper kept in the top drawer. Employers need to ensure that their employees have read and understood the directions in the policy. Some further strategies to ensure proper implementation of policies include having all employees acknowledge via a HR software or return email that they have read, understood, and will comply with the policy. Create mandatory e-learning modules on the content of the policy. Conduct training sessions and seminars on the practical implementation of the policy. For example, training on anti-discrimination, harassment, and bullying. And keep copies of policies where they are easily accessible, including in folders, policy manuals, and on an intranet system. Employers should also review, revise, and recirculate the policy regularly. Best practice would be to review a policy annually and be sure to note on the policy when it was last updated. Finally, an employer should refrain from allowing workplace policies to be incorporated into the employee's employment contracts, as this may create exposure to claims for a breach of contract by their employees in the event that the employer failed to comply with the workplace policy, claiming that the workplace policy was an incorporated term. To avoid this, policies should always be provided separate to the employment contract. That concludes the main part of our webinar. You might find our publication on the screen useful, Employment Essentials Fact Sheet, in the Resources tab or by scanning the QR code. You might also be interested in our upcoming event, Employment Law Update for In-House Counsel, which will take place on Tuesday, the 15th of October, and you can register now by the link on the screen. We're going to answer your questions shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of everything and all of your business as usual legal work, so you can focus on running your business. We also offer a dedicated service for in-house teams and general counsel to manage your high-volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. To learn more about how membership or desk extension can help you, request a free consultation when the survey appears at the end of this webinar. And now we'll answer some of your questions. Can the sexual harassment policy be part of the ADHB policy, or should it be separate?
Yeah, great question. Great you're thinking about having a policy that deals with sexual harassment. The short answer to that is it can absolutely be part of the ADHB policy, but if your preference was to separate it, then you can as well. But it can absolutely go within the one ADHB policy.
Great. We've got another question here. Do you need to consult with staff about every policy and procedure?
Yeah, another good question. So I think, as Amelia mentioned in the implementation section of policies, the first kind of important part of all of this is making sure that it's actually provided to employees. And ideally, we want them to respond or confirm in some way that they've read, that they've understood, and they'll comply with the policies. Of course, consulting with employees about the policies can be a helpful part of ensuring that they understand it, reminding them of the requirements as well. And so while in one sense, you may not need to practically consult with every single employee about every single policy and procedure that you have, consider ones that will be relevant and important, particularly those core policies that we talked about, to remind them, to train them of as well. And there could be situations where it is important to consult with them. So for example, in work health and safety, that you're consulting with employees about risks to their health and safety. And if you're implementing a new piece of equipment or machinery, it could be appropriate to be consulting them about that as well, if relevant. So the upshot here is you may not need to consult everyone all the time, but there's definitely value in doing so where reasonable and where appropriate.
Yeah, that makes sense. Thank you, Dickson. We've got another live question. Could a ADHB policy be part of a code of conduct, or should it be separate?
Yeah, this is another one where there's not a strict rule here. If you want to have a code of conduct which incorporates the prohibition on bullying, discrimination, and harassment in the workplace, you absolutely can. But if you want to have it sit in a separate standalone policy to kind of specifically highlight bullying, discrimination, harassment, then that's fine. And your code of conduct might deal with more, general behaviors in the workplace. So it's again one where I think either way would be fine.
Yeah. Okay, we've got another question here around a shutdown period. So if an employer has a shutdown period of 1 week at Christmas, can they insist some employees take 2 weeks leave by stating they only need skeleton staffing? And if the employees don't have 2 weeks annual leave accrued, they can insist it is leave without pay, or can they have annual leave in advance to avoid hardship?
Yeah. Good question. And I can see that there are a few questions that relate to leave policies and directions to take annual leave. So what I might do is just take a very quick step back and address, whether an employer can require or direct an employee to take annual leave. The first principle here is that if the direction is reasonable, then it can be made by an employer. And under the Fair Work Act, there are a couple of examples that are given around what's a reasonable direction to take annual leave. One being a shutdown period, such as over Christmas and New Year. And secondly, where an employee's accrued what we call excessive annual leave. So we focus in on the shutdown aspect of that. Firstly, yes, there's generally a right to direct employees to take annual leave during a shutdown period. I suppose in this scenario presented, there might be a question of if it's a 1 week of shutdown, whether it's then reasonable to require 2 weeks worth of annual leave be taken. I think that's something that we can explore further. But in terms of if an employee doesn't have enough leave, doesn't have enough annual leave accrued to cover that 1 week or 2 week period, yes, it then becomes a case of unpaid leave generally that the employee would be taking, unless they have any other entitlements to leave that they can access. But yeah, usually if they don't have enough annual leave to cover that shutdown period, they might be taking a mix of annual leave and then unpaid leave.
Thanks, Dickson. That's very helpful with Christmas coming up as well. We have another live question. Would you please provide some further clarity regarding not referencing policies within the employment contract and why that's not recommended from a legal perspective?
Yeah, for sure. So the first thing I want to clarify here is that it's okay to have a clause in the employment contract which in a sense references your workplace policies and actually provides an obligation on employees to comply with your policies. So that is absolutely fine. And that's actually quite common, a pretty standard term to include in employment contracts. What we're wanting to avoid is actually incorporating terms of the specific policies into the employment contract. So, for example, if I use a parental leave policy as the example here, if we have a policy that says that employees are entitled to company paid parental leave, and we actually put those terms within the employment contract, I guess a lot of this depends on the wording of the terms as well, but it actually may create a contractual right for the employee to that paid parental leave, when maybe the intention was that it was meant to be a lot more discretionary, as well as it may be something that you decide you need to vary or cancel in the future, maybe due to financial reasons. If we actually build that within an employee's employment contract, then they arguably have a contractual right to it, and you can't just remove it without their agreement. So in summary, it's absolutely fine to have more of a general clause which says that you've got workplace policies, the employee needs to read them, understand them, comply with them as they're provided to them from time to time. But what we're trying to avoid here are creating any contractual obligations by incorporating the terms of the policies into the contract, which particularly might be terms that you may want to cancel or vary in the future, as they may relate to benefits for employees. Hopefully that clarifies it.
Thanks, Dickson. Another question is, it's hard to know what's supposed to be in an employment contract and what should be in a policy. Is it harder to enforce a breach of policy or a breach of contract?
Yeah, so I think it's an interesting question in terms of, I guess, the difference between the employment contract and the employment policy, what should be contained in them. I think this is definitely one where we'd be keen to discuss more with you, what exactly you're already including in your employment contract, what types of maybe operational type processes, procedures, expectations you want to set out in a policy. I'd say in terms of enforcing a breach, I think it starts with, well, what are you trying to achieve? Normally, when there is a breach of contract or a breach of a policy, we're thinking about whether we take any disciplinary action, whether we counsel the employee, whether we warn them verbally or in writing, whether we actually look at termination of employment, particularly if it's a serious misconduct, for example. In terms of actual breach of contract, there can be a question of, well, is that something that you actually take them to court over, you sue them for? So examples here could be if they breach their confidentiality requirements, if they breach any restraints of trade, which are often very difficult to enforce. And so the other aspect of this, and the other part of your question is, is it harder to enforce one or the other? I think a lot of this comes again back to, well, what are you trying to achieve? Have they signed the employment contract versus with the policies? Have they been given copies of it? This is why one of our main tips was ensuring that you have good records of them receiving the policies and acknowledging it as well, because otherwise it makes it harder for you to enforce. If you say, hey, you've bullied someone and you're not allowed to do that in accordance with that policy, and your employee says, but I never received a copy of that policy. I wasn't aware that I wasn't allowed to do that. The other thing, just thinking out loud here, would be in terms of enforcing policies, whether there's been consistency in your enforcement, that can come into play as well. So if I come back to the example of bullying, if you've observed bullying in the workplace many times before, but never really done anything about it, never called anyone out or said that that needs to stop, well, that could work against you in enforcing that policy against another employee. They could argue, well, you've never called anyone else out, so that seems like it's acceptable conduct and behavior. So again, keen to explore this further with you who've asked this question around, if there's anything specific you're thinking about incorporating and whether there's a specific breach of a contract or policy. My final note to this question is if we do have that standard clause around policies in the employment contract, which says that employees must comply with your policies, if they breach the policy, then arguably they've also breached the contract at the same time.
Great, thanks, Dickson. Another question we have is, how do we need to prepare our policies if we have branches in different countries?
Yeah. So not uncommon that we have clients who are based in Australia, but might also have offshore workers or workers based overseas as well. I've seen a mix of different ways to deal with this. One probably more common one is you could have different versions of the policies in each jurisdiction or in each country. Why that can be applicable and useful is because there could be different laws that apply in different jurisdictions. And so it is best practice to ensure that each policy is relevant and compliant with the laws in the particular country as well. The other reason why you might consider having separate versions of the policies, even though there could be a lot of overlap, for example, every policy might say you're prohibited from bullying, discrimination, and harassment, would just be you might want to avoid having one policy applying to everyone. That just becomes very long. So it says, if you are in Australia, then this applies to you. But if you're in the UK, then this applies to you. So that can just make it a bit more of a lengthy document. In saying all of that, that doesn't mean you have to separate it out. If it streamlines it to have it all in the one document, you can do it that way. But again, best practice should just have it checked over from a legal perspective in each relevant jurisdiction to make sure it all remains compliant and effective.
Great. We have another question here around what is the best way to implement and share new HR policies across a business that hasn't had policies before?
Really good question. And so I think with implementing policies, Amelia gave a few really good suggestions earlier as well, but there's no one right way to do this. Some people like to print it out on pieces of paper and hand it to their employees and get their employees to read it, sign it, and then you save a copy of their signature. Others have systems, platforms, intranets where those policies are all uploaded. And there's functionality for employees to go in, read it, and then maybe tick a box at the end that they've understood it and will comply with it. Another common way would just be to send emails out. Send an email out to the team to say, here's a new policy that we've implemented, or here's an update to the policy that we've introduced as well. And again, require your employees to read it and reply back to you by email to confirm that, again, they've understood it and will comply with it. Now, there's a practical element in all of this to consider, which is, if you've got a team of 100 people, it could be a lot of work and an administrative burden to ensure that all 100 people return the policies to you or confirm by email. And so while that step of getting their confirmation isn't a legal requirement as such, we do think it's best practice to help mitigate the risk of the employee being able to say in the future that they never received it, or even if it did land in their email inbox, that they never got a chance to read it because they were tied up with something else. So yeah, hopefully that helps in terms of starting to think about implementing. A lot of it really just depends on the size of your business, the resources available to you, and ways that you think that will be helpful to provide the policies and to help your employees understand them and be reminded of them as well.
Thanks, Dickson. Another question that we have is, can I use the word discretionary in a policy, such as in a 4-day work week? So if it's not written into the employment contract, does this mean that I'd be able to ask my staff to go back to a 5-day work week at any time if the 4-day work week policy is discretionary and not written within the employment contract?
Yeah, so the answer to that is yes. We can use terms such as discretionary in a policy. We can have, it can be a pretty standard term in a policy to cover variation as well, which will effectively say that the company or the employer has the right to vary the terms of the policy from time to time. And so yeah, actually with something like a 4-day work week, it might be something you want to introduce and test and see if it works well, see if it achieves the outcomes that you're looking for. But if it's not working out, then you definitely want to have the ability to say, sorry, everyone, that policy is not continuing. And so, yes, we can add aspects of discretion within the policy. Of course, when you're actually applying that discretion, something to just remember in the background to all of this would be, say if we're applying a policy differently to one person or a group of people within your workplace compared to others, that could give rise to discrimination considerations as well. So this all starts, getting a little bit more complicated and more considerations. But yeah, that's just something I'd be thinking about too. So yes, you can have discretion in there, but in a sense, be careful about how you apply that discretion. Yeah, that's what I'd say to that.
That's great. Thanks, Dickson. We've got a nice short one for you, but we've had someone ask us just to remind us of what the core policies are.
Yeah, great question. So the core legal policies that we talked about were the anti-discrimination, bullying and harassment policy. Secondly, the IT or information technology policy. And then thirdly, the work health and safety policy. And as a very quick reminder as to why these are the core policies, it's because they actually speak to legal liability. What I mean by that is if, say, one employee bullies another employee in the business, you actually may be liable for the actions of the bully. And so where you have a policy such as an ADHB policy, which prohibits that kind of behavior, that's going to be often your first line of defense as to why you shouldn't be held liable, assuming you've implemented the policy.
Yeah, that's great. Thank you, Dickson. I think this is the final question for today. As a startup, there seems to be certain policies that are unnecessary at the current stage of the business. For example, a whistleblower policy, conflict of interest policy, modern slavery, etc. Can these be left out of the first employee handbook? And is it advisable to commit to regular employee performance reviews, or is an annual review enough? So there's two parts to that question.
Yeah, two parts. So I'll answer the first part, which is around, as a startup, certain policies might seem unnecessary. We again come back to, we really recommend that you have at the minimum those 3 core legal policies that I just mentioned. They're really important. They help to protect your business as well, set expectations. But in terms of the other policies and what may be more operational type policies as well, no, you can absolutely just not have them for now and maybe introduce or implement them at a later stage where they become relevant. So for example, if you keep getting the same questions about the expense reimbursement process, whenever your employees spend money in relation to their work, well, you might actually want to address that in a policy, have that written down, provide that to employees so that they can just refer back to the policy instead of asking you, the same questions over and over again. Similarly, a leave policy is quite common here in terms of, if there are certain, say, notice periods for leave requests that you require for annual leave specifically, then yeah, that can be a good policy. Or if you want to have processes in relation to, where they must log their leave requests and all of that, then yeah, that can be helpful. But if none of that is really needed right now, or it comes up on more of an ad hoc basis, then yeah, it's absolutely fine. I mean, the other thing I'd say is we're kind of weighing up when you provide policies to employees. I've seen 100-page handbooks, which contain lots of different policies, and they can be very useful, but it can also be quite onerous for you to maintain and update that document, as well as giving a 100-page document for your employee to read and go through and make sure they understand. So sometimes it's about trying to find that right balance of policies that are protective, are relevant to your business. And finally, of course, as Amelia mentioned, in some cases, you're just required to have certain policies, say under a tender process, or because a client wants to see it, they require you to have it in that sense. So all of that needs to be considered. In terms of the performance reviews, it is really up to you what you want to, in a sense, commit to. You probably don't want to promise a certain, frequency of review, but if you did, let's say you made it an annual review, which is quite common, the thing you'd want to ensure is that you're not promising anything that'll come out of it. So with an annual review, there's no guarantee of a pay increase, for example, unless of course it's required by law, through increases in minimum wage. So yeah, I'd say an annual review is quite standard. But of course, if you want to do more frequent performance reviews, you absolutely can. And in some cases, if you've got an underperforming employee, it could be quite relevant and important actually to be doing that. I think you mentioned that was the last question, Amelia, and I'm looking at the list now and just want to acknowledge that there are quite a few other questions that were submitted. So thank you so much for taking time to submit that. I'm really sorry that I didn't get a chance to go through all of them, but what we can do, and hopefully to help you in whatever questions you have, and with your compliance from a workplace policies perspective or otherwise, is again, if you want to submit your details at the very end of this presentation, then we can discuss further with you how we can help you and your business. So finally, yeah, that's all we have time for today. But as I mentioned, there is that survey, and we really value your feedback. So if you're able to, really appreciate it if you can complete, it's about a 30-second survey, just so we can receive your feedback and see how we can improve. So thanks very much for joining us today, and I hope you have a great rest of your day.